Now, let's talk about the big picture and liability issues. The agency or the organization or the clinic is a fiduciary. Its job is to it's in a position of trust. Its job is to basically do what it promises and to do it for the benefit of the client, not themselves. The services are bound by rules or warranties. We set the rules. Warranties are anything on your website, anything you hand out, or anything you say that talks about the rules of the road, how treatment occurs, cancellation of sessions, payment, forms that have to be signed, all that. So all of that rule book is designed and set by us. But most of all, if we screw up, it's a breach of trust. Now, the supervisory role, as I noted earlier, the supervisor is responsible for actions of the supervisee done within the scope of employment. This is called vicarious liability or respondeat superiori. It means let the master respond. Its basis is in English law centuries ago. When a nobleman sent somebody out to do something, he screwed it up, and a claim was made against the nobleman, and a court ruled basically that because he was in charge, he was the supervisor, he was liable. Now, that is always out there, and that's why the use of the term supervisor is a problem. No matter whether it's on your letterhead or where it is, it does lock you into duty. And you can be liable for things that you don't know about. We'll talk about that in a bit, but in a specific instance. But just to illustrate this, as I mentioned earlier, negligent supervision is charged all the time. If there's anybody that is an owner or arguably a supervisor, they're going to get charged too under that theory. Most times when people are charged with negligent supervision in a civil suit, in a lawsuit, a malpractice action, it's not that the supervisor screwed up in any demonstrable way. It's simply that the vicarious liability is there. Now, negligent supervision would be of the direct negligence type, would have to do with failing to do what a reasonable and prudent supervisor would have done faced with the same circumstance. Now, that can relate administratively to background checks, hiring, internal standards, rules about boundaries, staff training, all those things. It can also involve, however, advice you gave in a given case, or that you did or didn't order the person to do something. And those would be examples where you have to put on the stand someone who can qualify as an expert, who looks at all the facts of the situation, says, do you have a professional opinion as to whether the standard of care for supervision was violated? And at which point, if you do, that you present that, and then the question is, what damages resulted? And the scare case are the ones where the supervisee did something to someone you didn't know was a client, or a case you'd never been discussed. And I've had quite a number of them. But in 1989, we wrote a book on sexual involvement therapists and clients, and we quoted a case from Illinois at the time where this isn't a court decision because it never got that far. What happened was that a licensee getting his supervised hours went for weekly supervision to a psychologist. And the psychologist had an understanding with him that he followed the code of ethics and whatever. He ended up having sex with a client. When the case blew up and a lawsuit was filed, the supervisor was shocked because he'd never heard this client's name, didn't know the client existed, didn't know the guy was treating her, knew nothing about it. Now, normally, if you're in the same clinic, that's less likely, but if you're just in a different part of the clinic or the client comes at a different time, you don't keep track of that stuff. So unless you have an accounting for all the clients, something we'll talk about later, you can easily have someone, the person decides to not talk about in supervision. And that's what happened. Well, the insurance carrier asked the supervisor explained all this to the carrier, and the carrier said, well, okay, but were you his supervisor? Well, yeah, I mean, on this form I have to sign, I am his supervisor for his license. He said, okay. They settled the case at that point. And the supervisor freaked out and said, you gotta be kidding, I didn't even know this woman existed. I had nothing to do with supervising the case. They say, but your supervisee did it. It was within the scope of employment in that the guy was working as a professional. It was a client. And the argument is not anything other than that you're accountable because you're the supervisor.